Hi guys! Hope everybody is doing well. We have Sabata here in the chat early asking who's got the watch. Funny story about that. Whenever I open my StreamYard, they did some updates and I think they're trying to make it easy to stream. By default, this Viverito Bush picture is always on my screen by default. And I always have to hide it before I start the stream now. I don't know what it is, but good question here. Perfect timing for the Who's Got the Watch. Hey to Alyss, and hey to Adventure Aaron. Good to see ya. So what we're going to be looking at today, this is from Ashleigh Merchant. We had heard, and thanks to Thugger Daily, he kept us in the loop like a month ago. There was a default judgment issued against the property that Fulton County, that they seized from Duke, Martinez, Arnold. And Whitaker ended up saying like, all right, hold on. My order that gave that default judgment, we didn't actually lift the stay that was in place. So I'm going to issue an order. Judge Whitaker issued an order lifting that stay, and then also rescinded her order of the default judgment. She gave Ashleigh Merchant and Martinez Arnold, she gave them until today to file their response or their motion to open up the default. So we're going to look at that. I read about, I think like 2 pages of it, and I got to a part and I was like, oh my gosh, we've got to go live. I'll let you know when we get to that part. Link is pinned in the chat if you're watching live. It's also in the description if you're on replay crew. And as with what you'd expect with a civil forfeiture action, you've got the plaintiff who's looking to claim and keep all this stuff. That's the state of Georgia here. And then they give you, it's always interesting to see this list of the actual items, the physical property that they want to take. So for Duke, we've got a Mercedes-Benz. We've got another Mercedes-Benz. We've got a Maybach. We've got a Corvette. We've got all these cars. We've got money. We've got handguns. So it's just interesting to see the way these items are listed as defendants. And let's get to what's going on. Now, Ashleigh Merchant does a great job writing this in a self-explanatory manner. So a lot of the time where I would stop and say like, hey, that means this, the next line, Ashleigh covers that for us. We've got claimant Martinez Arnold's motion to open default pursuant to OCGA 9-11-55B. So come now, the claimant, Martinez Arnold, they're going to refer to him as Mr. Arnold or claimant, by and through his undersigned counsel, the Honorable Ashleigh Merchant, and pursuant to 9-11-55B, we're just going to say 55B for short if we have to keep reading this, hereby respectfully moves this court for an order opening the default in this matter. So what do we have to support this? So here's the factual and procedural background. We're going to get into Mr. Arnold's lack of knowledge concerning the forfeiture proceedings. So on May 9th, 2022, this is the first indictment came down. Mr. Arnold was arrested at 355 Allison Drive, Atlanta, Georgia. Mr. Arnold did not live there. This was Jeffrey Williams' home, and has never lived at that address. Actually, no, that wasn't Mr. Scratch that, different address. But that was that day. He never received mail at that address. So this is how he's supposed to know that he's got all of his property coming up for a default judgment. He's not going to get the mail that's being sent to this address. When Mr. Arnold was arrested, the state seized property that belonged to him, including his car, jewelry, cash, and watch. So they've got this stuff attached as exhibits. We can take a look at the exhibits as we get beyond the initial factual background here. Mr. Arnold was held at the Fulton County Detention Center without bond from the date of his arrest on May 9th, 2022, until the date he entered a plea on December 16th, 2022, at some time between July and August of 2022. So now put this in the time frame. This is when he's in custody. Mr. Arnold was served with some paperwork which included a new indictment. Mr. Arnold was unable to make copies of any paperwork as he was in jail. Mr. Arnold was unable to respond as he was in jail and did not have access to basic materials for which to respond. Mr. Arnold also did not have access to documents that would be necessary to respond. Mr. Arnold was told, so this is key. Mr. Arnold was told that the forfeiture action was stayed until all the criminal cases were completed, and he believed that that meant his case was also stayed. Now, we've heard this context. Ashleigh's going to address it, but this is where we have Whitaker saying, whoa, hold on. all right, well, let me get this together and issue an order lifting this stay now, and we're also going to rescind this default judgment. Mr. Arnold was never served a copy of any motions or proposed orders in the forfeiture action. He was never aware that the state had filed a motion for default judgment, or that his case had ever been transferred to Judge Whittaker. He found out that the state had submitted a proposed order to Judge Whittaker, and that she had signed an order from a post on Twitter. So guys, this is where I stopped and I said, all right, can't just share the document. I've got to go live and I've got to sigh on screen. So we have these complaints coming not just from a prosecutor here and there. We know the gang investigators. We know they love social media. But in the last 2 weeks, we had the state, Fani Willis, file a motion to revoke Young Thug's probation because of a social media post he made, and apparently every other social media post that anybody made somehow in relation to that. Big bad Twitter, big bad social media world. But on the flip side, how is this individual, Martinez, Arnold, it could be anybody, it really doesn't matter. But how is it that when the state is moving to ask a court to issue a default judgment so we can keep the property we seized from them, how is it that they have to find this stuff out through social media, through Twitter? And I would guess Thugger Daily is the post on Twitter. This is what we're talking about here. All the problems, the issues that Fulton County District Attorney's Office has with social media. Yet social media is the way that these individuals are trying to take property from are finding out about the motions going on. Isn't that just crazy? So I read this and I said, we need the chat. I need the chat. Hope everybody's doing well since I went down a little tangent here with what's highlighted on my screen. Shout out to everybody who's rolled in the meantime. I see JT, Amy L. Trikisha, good to see you. I've seen you like everywhere, I feel like, in the last week. Larry, good to see you. Destined to be, seeing you all over as well. A lot of folks in here, I've been watching Millionaire Mel react to the Karen Reed trial one, and a lot of you that are in here today have been over there. If you didn't watch Karen Reed trial one and you want to, go watch Mel's recaps, Millionaire Mel. It's just hilarious. And put the chat up, you'll see familiar faces. Factual Lie, good to see you. Sapphire Ridge News, shout out to Sapphire Ridge News. You were just live covering, I saw an investigation into Jasmine Crockett. So, investigations, hearing someone's being investigated isn't that compelling to me, but I think Sapphire Ridge News has the tea on that there. Good to see you, Betsy. Kendrick's here for Always Forever for Life. Mixed Chick. We've got a lot of people. Mary W., good to see you. Peach Just Me. Miss Fatima, hey Fatima. Sea Travel says, hope all are doing well. Right back at ya. Right back at ya. How nice of Sea Travel. Thanks for being a member for 8 months. Andre Cook, good to see you. And Andre says, miss you guys. This deployment has kept me away. Where are you? I hope you're stationed somewhere that you're enjoying and has very, very good food. That's always my wish when I hear the word deployment. I hope it's good. I hope you're safe. And I hope there's good food. BJ, let's get to your guys' thoughts. BJ says, it doesn't seem right that the state can take personal property from a citizen under any circumstances. And the added layer here is we've had, to the point of exhaustion, we have discussed the way that the Georgia RICO statute, the conspiracy to violate RICO, the way that was used with the YSL indictment. The way to expand the boundaries of a crime, what constitutes someone doing an activity in furtherance of a conspiracy to violate RICO. And now anything that you can loop into that, put in that box, you get the biggest box ever, and whatever you can fit in there, whatever activities, if you can say that some property or money is tied to that giant box of anything you want to put in it, now all of a sudden we can seize your property. And we don't really take the proper steps to notify you when we're asking a court to give us a default judgment and just let us have all your stuff. So just crazy. I agree. Yeah, Alyssa says, I just know Duke was calling YSL Barbie as soon as she saw that. And you know what? There's a chance that Ashleigh Merchant either saw it pop up on a docket, like she got an update, saw it herself on Twitter. I mean, not for nothing, but if I was Ashleigh Merchant or any attorney, I would totally be watching Thugger Daily. So again, it's like, it shouldn't come down to someone having to see a post on Twitter. It just shouldn't come down to that. Destin TV says, good to see the gangs all here. That's right. The KNW gang is back. Mark Baumeister, hope all is well. Right back at you. Just good times here all around. Papa John says, thanks for all you do, KNW. Love watching. We love that you are here. Our pizza merchant in the chat. Oh, boy. So Mr. Merchant, Mr. Arnold, then immediately alerts Miss Merchant, his attorney, Mrs. Merchant, and asked if the stay had been lifted. If he had known that this forfeiture action was not stayed, and if he had been served with the motions filed by the state, he would have provided those to his lawyer and ensured that he responded immediately. Now, this is important because what's happening here is, the state, whether they were within the bounds, the timeline, to file a motion for a default judgment, like that stay was in place, but they still filed a motion. And just as a fact, a matter of fact, Martinez Arnold did not respond to that motion for summary judgment, right? So that's an issue, but is it really an issue if that motion shouldn't have been filed in the first place? Or if there was a stay in place? There's things that get in the way of, yes, technically he didn't respond, but here's why this default judgment should not be allowed against him anyway. He didn't know. He didn't know, and in fact, any reasonable person would believe that there was a stay in place. And I think I looked at it on Twitter. I know Happily Angry Lawyer did a video on it. But Judge Glanville's order did say, staying this matter until all of the cases in this indictment close out, right? So the deadline, the date of the YSL 1 ending, isn't the date that stay should have been lifted. And that's why Whitaker had to issue an order lifting the stay 2 weeks ago. So let's see what Ashleigh Merchant says here. Mr. Arnold does not dispute that he did not answer the complaint within 30 days, so he concedes that this case is procedurally in default. On March 17th, 2025, the court entered a default. Did they really do that on St. Patrick's Day? Oh my gosh, the state really probably thought it was their lucky day. Like, woohoo, the court entered an order granting this default judgment for us and gave us an order for the distribution of this property. The state, in all green for St. Patrick's Day, probably thought it was their lucky day for real. But then on April 1st, after noting that the stay of proceedings had not been lifted prior to the entry of default judgment, the court entered an order lifting the stay in the above referenced matter, and entered its order striking default judgment and order of distribution and setting a scheduling order. In the latter order, the court set a deadline of April 14th, that's today, to file any motions related to the property at any issue by any party, a deadline of April 21st for responses to any motions. And so, guys, between now and the 21st, we're always going to say, are you doing any other videos? When are you going to go live again? Apparently, it seems like sometime between now and April 21st. With the rate that the state seems to respond to things that don't personally hurt their feelings, I'd say leaning more towards April 21st, but maybe this personally hurts their feelings and we'll meet again sooner. And then we've got a deadline of May 5th. That's the date that the court will conduct a hearing on any pending motions and or claims to the property at issue. Mr. Arnold hereby timely files the instant motion pursuant to the court's scheduling order. Now, we saw that Whitaker didn't even need to hear for the revocation hearing. I do believe that procedurally this hearing will take place. I don't think Whitaker's just going to file her order from the bench and not hold a hearing. But that means we should get to see Miss Merchant, Ashleigh Merchant, the Honorable YSL Barbie, argue on the floor right in front of Whitaker. So I'm excited for that. Now let's see. That's Cinco de Mayo. Why do they keep timing this? We've got St. Patrick's Day and then April Fool's and now Cinco de Mayo as like the time frames in this. Argument and citation of authority. So we're 4 pages in, and the bulk of this is going to be case law. Now, my guess is that, as usual, this is what we're going to have lacking in the state's response, unless they do this so often. Maybe they have a copy and paste template for civil forfeiture where they can just copy and paste some, case law that's been put together previously. But as far as any pertinent, specific, particularized arguments to what Martinez, Arnold, and Ashleigh Merchant are arguing here, I don't think we'll have anything that's more than just a copy and paste template in the response, but we'll see. We'll see. And I'm seeing this, Peter Steele. Peter Steele says, does anyone know if ADA Love is still trying cases? She actually just got a conviction last week in a case that seemed pretty cut and dry, wasn't a gang case. Really sad, crazy story. Guy walks up to guy with dog, wants to find out how much the dogs are, tries to rob the dog, I guess, and then shoots the guy with the dog because he won't just give up the dog. So, real sad case. I tweeted it at the end of this video. I can go back and get a link, but that was a week ago she scored that conviction. So, and again, facts are simpler, the charges are simpler. It wasn't a RICO case, wasn't a gang case, but she's still out there. Love is still out there. So let's see, under Georgia law, a party may open default as a matter of right within 15 days of the default by paying costs and filing defenses. We're going with 55A here, shorthand. Beyond that time, and quote, at any time before final judgment, the court, in its discretion, upon payments of costs, may allow the default to be opened for providential cause, preventing the filing of required proceedings, or for excusable neglect, or where the judge, from all the facts, shall determine that a proper case has been made for the default to be opened, on terms to be fixated by the court. So lots of room for the court's discretion here. In order to allow the default to be thus opened, the showing shall be made under oath, shall set up a meritorious defense, shall offer to plead in stancer, and shall announce ready to proceed with the trial. As a condition precedent to the court's consideration of whether any of the 3 grounds has been met, the defendant must show compliance with 4 statutory conditions. By 1, making a showing under oath. So, we might see Duke take the stand, but he does also have an affidavit here attached. 2, setting up a meritorious defense. I wasn't served. I had to find out on Twitter. And here's why they shouldn't be allowed to keep this property. Offering to plead in stancer, and for announcing that they're ready to proceed to trial. All right, bets in the chat with everything that you know now. Do you think the state's going to pursue taking this to trial? If we get to this hearing on May 5th, do you think the state's going to be like, never mind, we don't want to even do a trial anymore for this stuff? For this long list. Should we look at the long list? I don't think this is that exhaustive. Knowing them, they're probably missing stuff. But what do you think? Do you think they'll just give up the trial? Do you think they'll go all the way? Whew. The rule permitting, we've got a lot of yeses and nos in the chat. We've got a mix. I could have asked the question poorly. I think I switched the question from, do you think they'll go forward with trial, to, do you think they'll give up the trial? That's my bad, chat. I messed up the questions. Drayson says, take it to trial. Sapphire Original says, oh, they're going to trial. Let's see. Peter Steele says they're scared of Ashleigh M, so no. And don't forget, this, when Whitaker during YSL Trial 1 was like, do you really want to call another attorney to the stand? That was in direct reference to Ashleigh Merchant. So, oh, that was a good moment in Trial 1. Adventure Aaron says they might. The burden is lower in civil court. I think they'd be more likely to take Thug to trial. And that's what's interesting. I mean, I didn't really check for it. Again, Thugger Daily had grabbed this. So it'll be interesting to see if we also get some type of filing for Mr. Williams here. That'll be interesting. And I think, not to minimize the amount of property that they're looking to keep that's from Duke. But, you know, Jeffrey Williams has even more than what we're seeing them try to take from Duke. So that's the bigger money pot. There's two big money pots here. Asset pots. And yeah, I think Jeffrey Williams is the bigger one. To trial they go, says to making it count. Trikeisha says they'll go all the way. For always, forever, for life says trial. Del Hotchkiss says nope. Bonnie always thinks she's right, so going to trial. What the F said, and again, always love the name. They will never just give up. Good to see you, Kat. Good to see you. What the F. Black Butterfly says, and thanks for the 2. Says, hey, Kat, they are taking it all the way. For sure. For sure. I'm in that boat. I think they're going to take it all the way. Successfully, I don't know, but they're going to try. Also, Trikeisha. Huge thank you here to Trikeisha. 5 gifted subs in the chat. That means 5 people are green. We still have some YSL trial emojis. So if you are a member, if you just became a member, you can use those. Pick your favorite one, throw it in the chat, and give a big thank you here to Trikeisha. Thanks so much for supporting the channel. And let's see. I think we were a little further. We were here. So the rule permitting opening of default is remedial in nature and should be liberally applied, for the law favors deciding cases on their merits whenever possible. Upon a filing by defendants meeting the 4 conditions precedent, you see, when 2 words are spelled the same, but there's different words, precedent and precedent, reading it on a stream, I'm like, oh my gosh, this is going to beat me up. The trial court may properly open default, and the court's discretion will not be disturbed absent manifest abuse. So again, this is, I mean, the trial court can properly open default, and the court's discretion will not be disturbed unless it's manifest abuse. So this means the court has huge discretion, again, a very liberal application to grant this motion here. We've got more from this case that they're citing here, Patterson v. Bristol Timber from 2007. Trial court has broad discretion to open default, which will not be disturbed on appeal so long as all conditions set forth in 55 have been met, and if the trial court did not abuse its discretion based on the facts particular to the case. We've also got that from Miller v. Tranokos. To this end, the statute permitting default to be opened for providential cause, excusable neglect, or a proper case should be liberally applied in keeping with the policy of deciding cases on their merits. So we've got the Exxon Corporation making an appearance here in Exxon Corp v. Thomason. And then familiar names here. The next case we're citing is Copeland v. Carter. I don't think it's that Copeland or that Carter. Defendant presented specific evidence of facts showing the existence of a meritorious defense to the allegations of the complaint. The appellate courts will uphold the trial court's decision to open default if the record sustains the decision under any of the 3 grounds contained in OCGA 9-11-55B. Because, quote, the public policy of this state strongly favors resolution of cases on their merits, the remedial provisions, like this is just case law after case law after case law after case law. And the state's going to respond. I'm sure they've got their counter case law kind of ready. But so far we have like a whole page of case law here. But the remedial provisions for opening a default are to be forgivingly applied. Strader v. Palladian. We've got a whole bunch of cases here, you guys. For this reason, a default should generally be set aside when the defendant acts with reasonable promptness and alleges a meritorious defense so as to avoid a drastic sanction that should be invoked only in extreme situations. So again, at least as far as the reasonable promptness, he sees the tweet, contacts Ashleigh Merchant, and they're like, oh my god. So they responded promptly. Whitaker, in my opinion, responded promptly. And they're responding by the next deadline today that Whitaker set in place. Mr. Arnold has satisfied the conditions, so we're there. As a condition precedent to the trial court's consideration of whether any of the 3 grounds has been met, and again, it's any of the 3 grounds, the defendant must show compliance with 4 statutory conditions. So 1, the showing under oath, 2, setting up a meritorious defense, 3, offering to plead in stancer, and 4, announcing ready to proceed with trial. So here, Mr. Arnold has satisfied all 4 of these things. Thus, the court is authorized to consider the facts set forth in 55B. First, Mr. Arnold paid the costs. Now, they're going to attach this. This is a boring exhibit, but, where is Exhibit 2? I've seen some filings where this isn't attached. Where is it? Is it this? Yeah, so they attach that they've paid the appropriate fines because that's a requirement. And it seems stupid, but procedurally, the clerk will reject your filing. Your filing will be deficient if you don't do this basic thing that the court's asking you to do. And I haven't even dove that deep into civil forfeiture cases. I've looked at a few here and there, and still in just my small sample size, I've come across on the docket where something's deficient because they don't meet this criteria. They don't do this one little thing. So it seems stupid, but we're attaching this proof of payment to show that we paid these fees because it's a requirement. So they get that checked off. Second, Mr. Arnold made the requisite showing under oath in his affidavit and in verified answer and defenses to plaintiff's complaint. That's going to be called verified answer, which is in full compliance with the requirements of OCGA 9-16-12. So let's finish this paragraph and then we can read his affidavit. Third, Mr. Arnold's verified answer raises numerous meritorious defenses under OCGA 9-16-17. Mr. Arnold, through his verified answer, makes clear he is offering to plead in stancer. Fourth, Mr. Arnold also hereby announces that he's ready to proceed to trial. Based on the foregoing, Mr. Arnold has made the requisite showing for the court to consider opening the default. So these footnotes aren't, okay. Okay, so the footnotes are taking me to a footnote that tells us we have Exhibit C. That's why it's not jumping me to the exhibit. All right, so here's his affidavit. Affidavit of Martinez Arnold. Personally appeared before the undersigned officer duly authorized to administer oaths in this state. Martinez Arnold, who, after first being duly sworn, states as follows. My name is Martinez Arnold. I am a current resident of Fulton County, the state of Georgia. I make this affidavit based upon my own personal knowledge and belief. I'm over the age of 18 years, and I suffer from no disability that would render me incompetent to make this affidavit. So this is all the formalities of, signing something under oath. On May 9th, 2022, I was arrested at 355 Allison Drive, Atlanta, Georgia. I did not live there and have never lived at that address. I have never received mail at that address. When I was arrested, the state seized property that belonged to me, including my car, jewelry, cash, and a watch. I was held in the Fulton County Detention Center without bond. So, I couldn't get out. I couldn't go check somebody else's mail at a house that I never lived at because I was being held without bond from the date of my arrest in May 9th, 2022 until the date I entered a plea on December 16th, 2022. At some time between July and August of 2022, I was served with some paperwork which included a new indictment. I was unable to make copies of any paperwork as I was in jail. I was unable to respond as I was in jail and did not have access to any basic materials for which to respond. I also did not have access to documents that would be necessary to respond. And again, we saw that Ashleigh incorporated this into her arguments above. I was told that the forfeiture action was stayed until all the criminal cases were completed, and I believed, and I'm interjecting here, that's a reasonable belief, that meant my case was also stayed. I was never served with a copy of any motions or proposed orders in the forfeiture action. I was never aware that the state had filed a motion for default judgment or that my case had even been transferred to Judge Whitaker. I found out that the state had submitted a proposed order to Judge Whitaker and that she had signed an order from a post on Twitter. I immediately alerted my attorney and asked if the stay had been lifted. If I had known that my forfeiture action was not stayed, and if I had been served with the motions filed by the state, I would have provided those to my lawyer and ensured that I responded immediately. We get his signature here. And let's see, this is just going into his payment again. Let's go back up to where we were. So we've got 2 of the 4 criteria. We're signing this under oath. This is, we didn't respond within the time frame because we weren't properly notified. And we also have that we've paid the court's fees. Let's see, we were here. So there we go. Mr. Arnold has demonstrated that excusable neglect justifies opening the default. So yes, Arnold neglected to do this thing, but it's excusable because he was never notified. Excusable neglect does not mean gross negligence, and it does not mean a willful disregard of the process of the court, but refers to cases where there is a reasonable excuse for failing to answer. So, citing here Bowen v. Savoy, In re Turk, and Georgia Farm Buildings, Inc. v. Willard. So you got 3 cases there. The term, quote, inexcusable neglect, as used in this code section, refers to a, quote, reasonable excuse for failing to answer, as distinguished from willful disregard of the process of the court. Now, chat, I feel like I'm giving, like, gimmies away with the polls here, but put a 1 in the chat if you think Martinez Arnold has a reasonable excuse for not responding to the state's initial motion for default judgment. Put a 2 if you think it's unreasonable. We've got a 1 and a 2. 1 if you think Martinez Arnold has a reasonable excuse. 2 if you think his excuse is unreasonable. So here, Mr. Arnold should be allowed to open default for excusable neglect. As an initial matter, Mr. Arnold has not willfully disregarded the process of the court. Mr. Arnold has explained that he was incarcerated during the time the forfeiture proceedings were served, and he believed the case had been stayed. He remained incarcerated until 2022, and while in custody, and I mean, to be fair, he was incarcerated in 2022 and then until December 2022, so this could be contextualized a little better. This is like one thing. I've got one criticism so far of the way this is written, and it's super minor, because I understand it without it being spelled out. But just semantically. And while in custody, he was unable to make copies of any paperwork and unable to respond since he did not have the basic materials with which to respond. Mr. Arnold also did not have access to documents that would be necessary to respond. He was told that the forfeiture action was stayed until all the criminal cases were completed, and he believed that that meant his case was also stayed. And again, it's going to repeat these things. He was never served with a copy of any motions or proposed orders in the forfeiture action. He was never aware that the state had filed a motion for default judgment, or that his case was even transferred to Judge Whitaker. He found out because of the post on Twitter. Both of them, the proposed order and that Whitaker signed the proposed order. Mr. Arnold then immediately alerted his attorney and asked if the stay had been lifted. If he had known that this forfeiture action was not stayed, and if he had been served with the motions filed by the state, he would have provided those to his lawyer and ensured that he responded immediately. So under these circumstances, Mr. Arnold respectfully asks this court to forgive his delay in answering the complaint, find that his reason for doing so was due to excusable neglect, and permit him to answer the complaint and proceed to a trial on the merits. So, do we have any trolls in the chat that said 2? We're going to go through this. We've got Fatima with the 1, Factual Live with the 1, Quirky Marie, good to see you. We've got 1s. Oh, we've got a 2. Shout out to the truth is you lied with the 2. We have a 2. We've got a Taco Tuesday with the 2. Nice. We've got lots of 1s coming in. Look at them flowing in. And it just makes sense. I mean, how do they not have his address, his actual address, or just like mailing it to his place of arrest? Which, I don't know. Let's say, chat. Somebody in the chat, don't participate if you happen to work in law enforcement. But chat, just pretend, role play, you're getting into the law enforcement field. You're out in the fields. And you're about to respond to a scene. There's some people at a house. Do you just notate? Do you expect that everybody that's at that residence must live there? That that's actually their address? Their primary address, just because they happen to be there at that moment? So, like, come on. How do we not even consider that that's not the way to, send a filing to somebody? How do we have an address on file that someone's never lived at? So LL, this will be interesting to look for in the response. Are we going to have the state try to say that they notified Ashleigh Merchant. What are they going to say in their response? And I'm not speculating that that happened or that they're going to claim that happened. But it is an argument that if the state feels they have a good faith basis, and I mean, their definition of good faith basis seems to be a really, really loose definition, they could raise that argument in their response to this. You know, here's why we don't think it's an excusable thing. And maybe based on what they put forth, we'll scrutinize and be like, oh, they waited, they sat on it, maybe this isn't the way they painted the picture. But based on my, what I've watched from the state previously, and I think Ashleigh Merchant, arguments that I've seen her put forth, I don't have a reason to believe that she makes arguments in bad faith. So we'll see on this one, Ella, but you're right, this could be something that the state could respond with. Let's see. Chloe Albert's Revenge, good to see you. Says, yes, that's constructive tenantship. No, we're not going to do constructive possession and constructive tenantship now. Anyone that's ever walked in the door somewhere is now a tenant of that residence, that address. I love and hate that, Chloe. Good to see you. Britta, good to see you, says KNW Gang, missing the chat and the cat. Well, glad to have you here. We missed you too. I think you were in our last chat that we did, so it's not like you've missed anything. We just haven't been getting together as often. The Honorable, what was the basis for the seizure anyway? You know, the theory is, and I'm sure we'll see this argued, you know, if we get past this, if this is granted that they can argue to open this default, we're going to have this back and forth. You know, the state's going to say, we have the right to this property because, you know, it was acquired through the commission of crimes, through illegal activity. And then we'll have the response from the defendant here, Duke, Ashleigh Merchant, saying, no, that's not the case. Here's when he had these vehicles and you're accusing him of crimes in this time frame. That couldn't be the case. And there might be different arguments for different assets. There might be an overall argument relating to, you know, he pled to these things, but you don't have any evidence showing that this property was acquired for this thing that he pled guilty to. So there is going to be a back and forth if we see this go to trial on the basis for seizure and the counter arguments by Duke and Ashleigh Merchant here. So, and you know, I'm excited to see them argue that. I don't know who's going to be arguing for the state, but I'm sure Ashleigh Merchant's ready for any opponent. Oh my goodness. Just crazy. And let's see. Okay, yeah, so let me clarify something from the beginning of the trial, the stream. This address is throwing me off. Where is it? Where do they say it? Wherever the street address was. Okay, yeah. 355 Allison Drive, Atlanta, Georgia. This is Jeffrey Williams Sandy Springs property, but it's just the address is, the city is listed as Atlanta, not Sandy Springs, but this is Jeffrey Williams' address then? This is where they're getting that from? Because I was confused reading it. I started to say it was Jeffrey Williams' property, but then I'm like, wasn't that Sandy Springs? But I guess some parts of Sandy Springs that people call Sandy Springs, or where Sandy Springs Police Department has jurisdiction, the mailing address might actually be Atlanta as the city. So, okay, yes, okay, so correcting the correction 3 times now, 2 times from the beginning of the stream. This is Jeffrey Williams' address. It's just listed as Atlanta, even though it's commonly referred to as a Sandy Springs property. Thank you, Adventure Aaron and chat here. Where were we? We got the signatures here, right? What do we got? What argument did we just finish off? Okay, so we left off here. Next argument is that Mr. Arnold has demonstrated that a proper case has been made for default to be opened under all of the facts. The proper case ground has been, quote, construed to confer discretion on the trial court broader than that conferred on the 2 other grounds, as if reaching out to take in every conceivable case where injustice might result if the default were not open. Yeah, this is a pretty wide range of discretion. As if reaching out to take in every conceivable case. We've got tons of case law here cited. Let's see. The proper case inquiry is intensely fact-specific, though case law can offer some guidance. The appellate court's review of a trial court's determination as to the reasonableness of a party's explanation for being in default, quote, is exceedingly deferential, and its decision finding a, quote, proper case for opening default will be reviewed for a manifest abuse of discretion. Again, so really it seems like the state's got to respond here and make a showing if they want to oppose this motion. And I'm sure they will. If they want to oppose this motion, they've got to overcome this, why should the court deny this? Why should the court find that what Ashleigh Merchant's doing here is a manifest abuse? Or if we were to grant this, why should we believe that this would be a manifest abuse of the court's discretion? So I'd be very interested in seeing the state's arguments for that. Applying these principles to the facts here, Mr. Arnold also believes that a proper case has been shown to open the default. The value of the property at issue is significant and personal to Mr. Arnold. I think that's including his Duke chain. So literally his name, or his nickname. The property at issue is valued at well over $255,000. The property consists of 4 main types: Mr. Arnold's vehicle, jewelry Mr. Arnold purchased, Mr. Arnold's jewelry that he received as a gift from a close friend, and cash that Mr. Arnold had earned days before his arrest. Now, this is where, if we go back to, the Honorable that's question here, what was the basis for the seizure? I'm not saying that I would agree with it. I don't think there's an argument here, but it would seem that the closest, just situationally, that the state could argue cash right before he was arrested. Well, was he employed? Was he making money? We know he was doing music, so Ashleigh's going to be able to come up and say, he had this money on him, but he earned this money through, here's his records of how he got it. Here's payments for a show he did, or something relating to a work contract. And the state's going to have to be like, we think that was cash acquired through something illegal, and here's our proof for that. So, I don't really know how they're going to say a gift. Like, they're going to have to go back and say a gift from a close friend. This gift, was it from another YSL associate? Or an associate of any of the gangs that Duke is a dual member of? Like, they're going to have to make specific arguments for each piece here. And then Merchant here is already saying none of this property has any nexus to the crimes for which Mr. Arnold was charged and to which Mr. Arnold pled guilty. So this is interesting. He didn't plead guilty to everything. But Ashleigh's taking it all the way and saying none of this has a nexus. There's no nexus here for any of these items to anything that he was charged with, let alone what he actually pled guilty to, where there's a disposition for. Mr. Arnold pled guilty in this case for an offense that happened in 2015, years before he acquired any of this property. So, come on. This property was not purchased with proceeds from any crime, was not used to effectuate any crime, and is not contraband in any way. And arguably, if the basis for the forfeiture is what you indicted him with, whatever was in the indictment, the May indictment or the second indictment, if it's related to criminal activity that's not included in that indictment, then we still have a secondary problem here. So was it tied to criminal activity at all? Isn't enough. Was it tied to criminal activity to which he was charged and pled guilty for? So, looking over here, Trikeisha says the state is so desperate. I mean, this is a huge sentence. It's short and simple. It's short and simple. Mr. Arnold pled guilty in this case for an offense that happened in 2015, years before he acquired any of this property. Short and simple. No nexus, totally different time frames. Unless the state has a good counter to this. This property was not purchased with proceeds from any crime, was not used to effectuate any crime, and is not contraband in any way. For the state to be able to take over, and I think I read some of the, because some of this is Jeffrey Williams. I mean, I guess we could see some arguments maybe in terms of Jeffrey Williams' property, maybe some of these firearms. I don't remember which one, but one of these firearms had like a modification, right? So I don't know if that's like contraband by definition, or if the modification itself would be contraband, and if they do anything to work out, well, you can have the property back, but we're taking the modification off. I don't know the particulars there. But for Duke, that doesn't apply. For Duke, that's not going to apply. Where were we? Okay. So for the state to be able to take over $255,000 of property that belonged to Mr. Arnold and was not used to facilitate a crime, nor obtained as a result of any crime, would be tantamount to the state stealing from Mr. Arnold. Chat, where's the watch? Where's the watch? Whew, where is the watch? And it's just, it's... Personally, I have strong opinions about civil forfeiture in general, right? But when we zoom in, we're speaking in the context of Fulton County and property seized from people that someone in the gang expert team alleges to be a YSL member or YSL associate. My red flag, my skepticism towards the civil forfeiture process is even greater in this context. So, wait, it was a starter pistol? And a switch. Switch. Thanks. So, and that's the thing, like, they can make the argument about this whatever with this thing, I guess. But they don't really even know whose was who, right? Wasn't there an issue on the ownership, who it actually belonged to? Because not only were they trying to charge Jeffrey Williams, Martinez, Arnold, but they also tried to charge Diamante Kendrick. And to me, they muddied the waters. Like, they tried to charge everyone with constructive possession. And they didn't really identify any single person as being the actual owner. So... so they might not get it back, but also, like, who are they actually taking it from? Yeah, LL says, where's the watch in my best Dougie Fresh voice? But this probably felt good to write. This would be tantamount to the state stealing from Mr. Arnold. All because he happened to have this property on his person or was parked at the location where the arrest warrant was served, even though it has no connection whatsoever to any crime. The property was not transformed into proceeds of a crime or property used to commit a crime, and the state will not be able to prove otherwise. The state will not be able to prove otherwise. And if the court does not allow Mr. Arnold to open the default, it will result in an unjustified windfall for the state, encourage the state to continue improperly seizing assets from Georgia citizens, and result in a miscarriage of justice on the merits of this case. For all of these reasons, and again, I love this. I get that, to me, this is a zinger, right? It's going to encourage the state to continue to improperly seize assets from Georgia citizens. But I like when attorneys round out, when you're asking the court to do something and you have the ability, you're not just pulling it out of your butt, you actually have the ability to say, this would be an injustice to my client, but it would also be an injustice to the public. When you have the ability to do that and you include it, I just think it's great writing. I think it's compelling. I think it's a good argument. And the court, again, they're asked here to consider this specific case with the relevant parties. But this is, in my opinion, a pretty big matter of public importance. So, for all of these reasons, Mr. Arnold respectfully requests that the court open the default, allow Mr. Arnold to answer the complaint, and proceed to a trial on the merits. The chat's asking the court, too. The plaintiff has not shown and cannot show. So, here we go. We're going to expound on this. They can't show what they're supposed to demonstrate. So, the plaintiff, the state, has not shown and cannot show that it will suffer any prejudice as a result of the court opening default. So in addition to the factors set forth in 91155B, the court may also consider whether the party will suffer any prejudice as a result of the court opening default. All these cases again, noting that this court has recognized a number of factors for determining whether opening default would be appropriate in a particular case, including, but not limited to, whether and how the opposing party will be prejudiced by opening the default. They're going to say, Your Honor, we want this stuff. Whether the opposing party elected not to raise the default issue until after the time under 91155A had expired for the defaulting party to open default as a matter of right, and whether the defaulting party acted promptly to open the default upon learning no answer has either been filed or timely filed. And, this is a lot, and any additional delay occasioned by a failure to file promptly for opening default upon its discovery can be considered in determining whether defendant's neglect was excusable. Indeed, the Georgia Supreme Court has noted that whether the plaintiff will be harmed, and Georgia Supreme Court, you guys, so hang appellate decisions over the judge's head here, whether the plaintiff will be harmed or prejudiced by opening the default is likewise a universally pertinent consideration when the proper case ground is pled. So, let's see. We've got these cases again. No abuse of discretion in opening default on proper case ground where defendant, within 2 days of learning of the default, paid the costs, moved to continue the case, and filed notice of intent to move to open the default, which it did 12 days later. So we know that they did these things here in this case. And plaintiff presented no evidence of prejudice suffered by the opening of the default. So plaintiffs have demonstrated, more case law, guys. Plaintiffs have demonstrated no prejudice to their case by the opening of default, particularly since they waited 11 months after filing proof of service to move for entry of default judgment. The Georgia Supreme Court also noted that a trial court should bear in mind that this statute conveys very ample powers to open defaults. And in keeping with the policy of deciding cases on their merits, the provision should be liberally applied. So what do we got here? I think we know the main argument here, right? Applying these principles here, the state plaintiff cannot demonstrate any prejudice as a result of the court opening default. This forfeiture proceeding has been stayed for the most part since September of 2022. And this is a great point. You know, timeline being an issue, but this is so far removed. This is like 2.5 years ago from right now. So if the state's going to come in and argue, well, you know, you were ready to issue this default before you realized the stay was in place, court, and issued an order lifting the stay like 2 weeks ago. But now let's panic, it's too late. You know, 2 weeks, it's been too long. You should let this die. Don't let them open this default. How do you square that with something that's been going on since 2022? So we can't complain about the timeline here because, quite frankly, the timeline has already been stupidly long. Discovery was likewise stayed in September of 2022. The forfeiture statute does not provide for a right to discovery, and Mr. Arnold is not asking this court to permit him to engage in discovery. The entire case has been on hold and remains in the same procedural posture it was before the case was stayed. So the plaintiff has not had... All right, we got a second minor issue here from Ashleigh Merchant. Just 2, chat. Plaintiff has not had engage. We're missing 2. I think this should be plaintiff has not had to engage in extensive litigation or expend any material resources or time on this matter. Yeah, I don't think they did much work except going, Judge, can we have this stuff now, please? For this reason, the state cannot show how or why it would suffer any prejudice by allowing Mr. Arnold to answer the complaint and proceed to trial. So Mr. Arnold respectfully requests that this court grant the instant motion and allow this case to proceed on the merits. Conclusion, and just real short, you know, prejudice, this time, the money burden. Even if there was discovery in this matter leading up to the request for a default judgment, that same discovery would also, if it was something that Arnold was entitled to. You know, the argument here is it was stayed and we didn't engage in discovery. The state didn't engage in discovery. But if that were the case, if they had to engage in the discovery, whether they made the motion for default judgment and it was granted, or they go to trial, it's still not prejudicial because it's something they've got to do either way, right? So this is saying that nothing that's occurred to this point has been unduly burdensome on the state to get here. They pretty much just sat there and said, Judge, give us his stuff. So in conclusion, for each of the foregoing reasons, Mr. Arnold respectfully requests this court grant the instant motion and enter an order opening the default, allowing... Oh, we have 3! Chat, we've got 3, but I kind of like this one. Allowing the Mr. Arnold. So we have a the here that shouldn't be here, but you know, we've got a lot of names. The Honorable, the... I think this one's a pass. We're going to say there's like 2.5 things. 2.5 typos in this document. Allowing the Mr. Arnold to file his proposed answer and affirmative defenses to the complaint, and allowing this case to proceed to a trial on the merits, respectfully submitted this 14th day of April, 2025, the Merchant Law Firm, Ashleigh Merchant. We've got John's email down here too. So there we go, you guys. The document is pinned in the chat. It's also in the description if you're on replay. Lauren says, I guarantee you that money is gone. Now, don't forget, we had an issue with the Nathan Wade special prosecutor, his payments. You know, he had 5-figure payments some months, like 36-something thousand. And one of the clerks said, oh, you know what? You guys are trying to say that something weird's going on because his payments are coming out of the civil forfeiture fund. But that has to be a clerical error because we wouldn't even have that amount of money in the civil forfeiture fund for that type of payment and that amount to be made. But lo and behold, I think the dollar amount, they had $115,000 or maybe $125,000 in cash that they had just seized from Jeffrey Williams. And I'm not connecting the dots and saying this specific money went in civil forfeiture account and that's the money that got paid to Nathan Wade. But what I'm saying is the excuse they gave to say, no, that couldn't be possible because we don't even have more than $35,000 in that account. It's just on its face not true. So that was a whole time. Good throwback here, Lauren, to talk about the civil forfeiture fund call out with the special prosecutor payments. Yes, Alyssa. Wasn't that coincidentally after their things were seized? It was the same time frame. It was a couple months, like... Because it was like, I don't know, the payments... November 2022, I remember looking at some of the logs. But also, like, I think some of the larger payments... The payments, like, varied. Some of them weren't, like, above, like, $20,000, but the ones that were, I think they were in that time frame. There were like 2 or 3 that were like $30,000 or more than that $35,000 amount. I do have a video on it where I do have the specifics in it. I think that was around like March of last year. So it's been a year since I've looked at the numbers, but I do have a video. That's actually one of the first videos I think a lot of you guys found this channel, was the civil forfeiture issue with that claim. Oh, it was a clerical error, but what about Jeffrey Williams and the liquid cash that you seized from him that's more than that amount? And I see a lot of people... Nem is saying TK verdict is in. I think Nick Starro is probably doing verdict watch for that live. I know he was watching for verdict on Friday. I have this stream is set to redirect over to Survivor Speaks, who's doing the Lori Daybell Lori Daybell trial. A mess for the facts of the case itself, but to add extra chaos, she's representing herself. So she's cross-examining witnesses. It's a time. So we'll be, this is set to redirect over to Survivor Speaks, is doing a stream on that. But I see the chat saying the verdict in the TK trial. They have a verdict in. Oh, and Classy's going live now for it. Okay. So, yeah, I don't think the verdict's been announced. I think that they just, they say we have the verdict in, get everybody to the courtroom until they're waiting to announce it. So, Franju P. Diddy with the haircut says, we're all getting the state's jobs after this. Heck yeah, we can be in one of their new hire bulletins. Let's all get in there. We'll put your profile picture on there. I would love to see that. Flesh of the Gods, big shout out to Flesh of the Gods here. FFS had messaged me that you were live. Maybe Saturday night, but I saw it Sunday morning, so I missed it. So big shout out here to Flesh of the Gods. Again, you guys hear me say it. Shout out to his interactive chat. I think I focus on that more than anything else because it's fun. It's cool. It like brings a little bit of the fun of the chat that you'd expect on a platform like Twitch over to YouTube. YouTube doesn't really give us many YouTube driven features to make the chat that interactive. Twitch does a lot more of that. But Flesh of the Gods using OBS, you know, in his backstage where he's producing his show, he's got all these things coded in that are super fun, like fire-breathing Adrian Love Dragons, and sound bites that the chat can trigger. So I always harp on that, but I want to give a bigger shout out. Flesh of the Gods does these deep dives, so these things that you would never... you know, a lot of people, we started to learn Martinez Arnold's name more because of, you know, Ashleigh Merchant, issues with the plea deals. But Flesh of the Gods has these deep dives on people that don't necessarily seem like the main character. He's got deep dives on Jeffrey Williams. He's got deep dives on Diamante Kendrick, Shannon Stillwell. But all of these things that surround, like the nuances, what was happening in 2016, 2017. He just is like a librarian for this archive of information. So big shout out here to Flesh of the Gods. Glad you're hanging out with us today. I'm just covering one measly motion, but he's got the deep dive goods over there at the Flesh of the Gods channel. So big shout out there. Let me get your link. And I always just use Fogs for shorthand. But there you go. Click the link in the chat. You're on your way to 4K subscribers. That's going to be amazing. Can't wait to party for that. Mary W. also says Lori Daybell is definitely worth a watch. She is something else. I'm telling you guys, I mean, pro se cases, people always seem interested in general. But she's a bit chaotic. So to see her representing herself in court, it's not like Darrell Brooks where he's like restrained and in another room and just trying to be loud. I mean, she's still allowed in the courtroom. She's not gagged, and she's been quite chaotic. Chloe Albert's Revenge says, is this the constructive tenants? Wherever you are when the police arrive is your new address. Today, I'm headed over to Trump Tower after work to get the cops called on me. They're going to send all your mail there. They're going to send all your mail there. Oh, holy moly. Although maybe someone, you know, I think those big buildings have like a clerk that organizes and says like, hey, this person doesn't actually live here, and sends it back. And then Chloe's also saying, does she say grounds? I do not believe that Lori Daybell is yelling grounds, but she is making some objections. She does have counsel sitting like as advisory to her as well. So... Adventure Aaron with the not legal advice, but maybe common sense advice. Get an attorney. Get an effing attorney. Yeah. Another thing, if you guys have seen the interrogation videos, the police interviews with Richard Allen, that man is chatty patty with two police officers, two investigators, for a long time. And they're like, do you want an attorney? He's like, nope. And then they use that exact information to rope him up, and now he's doing life in prison. So get an attorney. Get an attorney. Ask for an attorney. Or if you're not under arrest, say you want to leave. Say you want to leave. So just crazy. And I know, like, every time we hear someone do something without an attorney, the whole chat is like, no, don't talk to them. Don't talk to them if you're not under arrest. Don't talk to them without counsel. Don't sign anything without counsel. So I hope that this type of thing is becoming more common knowledge, and just because you think you're innocent, so there's nothing that you can say that would incriminate you, I hope more of us are coming to the realization that that's simply not the case. Just because you might be innocent doesn't mean that your words won't be used against you to incriminate you and then lead to a conviction against you. So sad that's the way it works. Big shout out here to Peter Ortiz. Says, hi Kat, we got to get some boom emojis in the chat here for Peter. Hi, cat and my fellow slime. We got the green amphibious snake emojis. So drop some booms or green amphibious emojis or hearts in the chat. Good to see you, Peter Ortiz. I almost mentioned tacos because Taco Tuesday is in the chat, but it is Monday. It is Monday. So, for always, forever, for life says stop self-snitching. There you go. There you go. Let's see. The Honorable Yeah That says, we, or maybe just me, humbly request your coverage of Karen Read Part 2 when it starts. Oh, been itching for some more K&W trial commentary. I will be watching. I don't have the bandwidth to commit, because I think they're estimating over a month still, right? Like 4 to 6 weeks still for round 2. I don't have the bandwidth. Plus, I really enjoyed watching. I'm going to add like Millionaire Mel to my rewatch if she's covering Trial 2 live. But for Karen Read Trial 1, I was like watching Andrea Burkhart live and then potentially Criminals recaps. And I was tuning into Melanie Little for interviews and filings that were happening. Like, I don't know. I think we had Legal Vices. Shout out to Legal Vices. Rest in peace. Uncivil Law. I mean, I couldn't think of all the different channels I was hopping to, watching the same part of the court day, just with different people throughout one day. So I will be in the chat for that. I don't have the bandwidth even if I wanted to, but I really do enjoy watching the Karen Read stuff in other people's chats. So I'll be around. If something super crazy happens, maybe I'll do a live and react to the day. But Honorable, yeah, that I hope wherever I go, I see you over there. So I will definitely be watching somewhere, probably twice a day. And my bandwidth, you guys, this thing that I've been talking about, we're supposed to be incorporating officially tomorrow. So we have our meeting with the attorney, going over the paperwork and final questions for our team, everybody that we're bringing on board. Yeah, that's the nitty-gritty happening tomorrow. So it's been a lot of work leading up to this for our company, this company, and it's going to continue to be a lot of work. But tomorrow is really the monumental day for that. So I will be in the YouTube streets for Karen Read too. Full drinking and half thinking. Chat, what's your opinion on Superman? What's your opinion on Superman? So big shout out to Full Drinking and Half Thinking. I've also got to give a shout out to Mixed Chick, because Mixed Chick let me know that at what time the live stream is going to be on Saturday this weekend. And we get in there, it opens up, and Full Drinking Half Thinking is like, Superman's a bitch. And I'm like, what did I get into? What did I get into? But it was great. It was a lot of commentary on, you know, relationship conversations and, you know, with superhero characters, sometimes a superhero is focused on chasing women. So that was an interesting, fun conversation. The chat was a great time. Let me get the link to that chat. Yeah, he's soft. He's soft. Thank you for giving me the more vanilla way to say it on stream. Let me get this link here. Go and check this out. Make sure you put the chat replay on, because you guys had me laughing on screen, but the chat, equally a good time. So this was Full Drinking, Half Thinking. Yeah, there you go. Flesh of the Gods says Superman gets beat up a lot to be the Man of Steel. So, there you go. Thank you for the congratulations, Frandrew. I'm really excited for it. I do want a little break. I do wish we could like incorporate and then I could not work for a week. I do want a little bit of a break. My brain is going to mush with work content. You think it's like, who wants to get on screen and read a legal document? And me, because it's something so I'm interested in it anyway. But it is such a nice break from the other work stuff. Big shout out here. Chloe Albert's Revenge says, and Flesh of the Gods features my products. Yes. So we know Chloe Albert's Revenge does you're like a full stack satire advertiser. You've got the jingles, you've got the product design, product development, and you've got all of the memorable marketing, like alliterative branding terms. So yes, Flesh of the Gods has all of Chloe's products, and I'm able to sell out and close customer service before they get to complain. That's the way to do it. And speaking of customer service, yeah, we're at that stage. We've got to expand our support tickets, customer service, software, all of the things that I really, really hate. I've consulted with other companies as they've grown, but I've never been in an ownership position, and now I have to do it from the perspective of an owner, and I really don't want to do it. Not my favorite thing. So shout out to our fun product designers and customer service runaways like Chloe. And then holy moly, Full Drinking and Half Thinking just gave out 20 memberships. So it's like, that's super, super awesome. Make sure you guys are saying thank you in the chat. I do see a lot of, we do the acronym, we do the FDHT for Full Drinking and Half Thinking. So big thank you here. Also tons of booms here in the chat. Seeing that, we got Peter Ortiz booms. We've got Peter Ortiz. We want you back. That's a, Jackson 5 song in my head now. But super, super thank you. I will try to... What do we have as the dates here, you guys? Let's go to our calendar. Let me just search for May, because oh, that's a bad word, because May is also a non-month word. May 5? Yeah, okay. So this is our tentative schedule for content on everything with the civil forfeiture. So the state has a deadline to file, April 21st. So between now and then, whenever they file it, we'll go and read their response. Will they be able to say there's a nexus between the property we want to take and crimes, criminal activity that we can tie Martinez Arnold to? Or actually, they're going to be responding against this motion to even open the order for default. So they're going to have to argue that this prejudices them to even open the default and move it forward to a hearing. So their response is going to be, don't let them fight this. So sometime between now and April 21st for that. And then May 5th. So May 5th is solid. That's not a range unless they decide to change the court's calendar around. May 5th should be a hearing. So let's expect to get together on Cinco de Mayo. Peter, bring the tacos. Peter, bring us some great refreshments for Cinco de Mayo. I'll put this on my calendar. We'll make sure we get together on May 5th for this hearing. And I'll post if they reschedule it. So, Destined to V says, I love superhero talk. I will check it out for sure. They went bananas. So, there was another debate. Daredevil versus Spider-Man. And like, who would win more often in fights? And I think, Full Drinking, were you the only one standing down that like Daredevil was the truth over Spider-Man? Because again, Spider-Man is, his mind is a bit preoccupied with his love interests across time and place. Yeah, Chelsea Lynn, good to see you, says the debate over superheroes was hilarious. You were hilarious in that chat, Chelsea. Shout out to Chelsea. Barbara! Oh my gosh, good to see you, Barbara. Any news on Courtney Clenny? Yes. Yes. So, somebody emailed the court in the Courtney Clenny case. Let me pull up the docket real quick. And I wrote to the DA's office, the state attorney's office, and I was like, I want to make a public records request. Can I request this letter from a friend? And they don't have it yet, which is how I know that it was sent to the court and not to the district attorney's office, the state attorney's office. Let me pull up the docket. And they're supposed to be deposing the former lead prosecutor. They delayed that. They moved that date back, but I think it might be this week. Let's see. Still no trial date, of course. Let's see, docket. Yeah, so I saw on the docket for Courtney Clenny, guys. We're talking about Courtney Clenny, OnlyFans model who is charged with murder for the murder of her boyfriend, Christian Obumseli, in their Miami penthouse apartment, which she says was her apartment, but he was, by all definitions, it seems like he was domiciled there. This case has been going on and getting delayed and delayed and delayed. What seems like a pretty open and shut, not justifiable self-defense, battered spouse syndrome defense. The state is messing it up. The prosecutors are messing it up. They're doing stupid things. They're looking at privileged communications and they're just all willy-nilly about it. So the lead prosecutor had to step down. A lot of commentary is saying that the prosecutors in the YNW Melly case are doing the same thing. Like, they're just effing around and throwing away a trial that they should have easily been able to make their case for by doing things they have no business doing. Like, they just have no limits. So that's why we still don't have a trial date for Courtney Clenny. And likewise for YNW Melly, he's awaiting retrial, but his total time in custody is like over 2,200 days or something like that. So right here on the docket, we've got this edition of Letter from Friend, and that's all it says. But I emailed the prosecutors right away. They didn't have a copy of it. So the court has to disseminate this stuff to all the parties. The clerk had probably just gotten it. I could send the request again and see if they've gotten it since. And now they've got something about pro se correspondence. And I'm assuming that might relate to this letter from a friend. So I don't know. Next on the docket is the 16th, so Wednesday. And that's a hearing for motion to take the deposition. I believe this is related to a deposition of Khalil Quinnan, the former prosecutor. Yeah, typically you see how these, I think this is at their character limit, but I believe these are the arguments that are going to be argued on the 16th. It's just too long, but typically the date would be right here for, we're going to hear this at the upcoming hearing. So a hot mess. Is there an update on an update on Mungoun from Fit Lawyer or Happily Angry Lawyer? So I believe they are filing this week. And I'm sure as soon as it's filed, I can't wait to look at that. I cannot wait to look at it. But as soon as it's filed, I'm sure at least one of them, if not both of them, I'm assuming both of them, maybe we'll go live and share their own updates. I don't know how extensive they'll be in their own coverage because they're still actively representing Mungoun and, the actions in progress. But anything that they are unwilling to say on stream, I will say it in the chats or go live myself and say it. Guys, I really think that their motion to vacate, what they're doing, they're going to do the motion to vacate the sentence. That's the first step. When they file that, I think some of the arguments are just going to be mind-blowing because it's not just going to be stuff that affects Mungoun. It's going to be stuff that it's the playbook that they throw at people over and over and over and over again. So while they're arguing issues specific to Mungoun's case and cases, I think we're going to see a lot of validations for the things that in common terms, outside of the courtroom, outside of legal filings, we sit here in the chat and we say, doesn't it seem like they do this all the time? It seems like they're just using this as a way to do blank. And I think we're going to see a lot of that. So I'm really, really, really excited for that. There's a similar case, not a similar case, but a similar story. I shared it today. This is local to me. This is Brevard County. This is down here in Florida. But I think you guys might like this story for several reasons. We're going to start with the attorney here. This was his post on Facebook. Kevin McCann is his name. He's representing Jeffrey Abramowski, who the state attorney for Brevard County just said, look, we're not going to oppose your motion to vacate his sentence, right? Prosecutor's not opposing it. So Kevin McCann listened to a podcast that was made in 2019, a true crime podcast that broke down some red flags in Jeffrey's case. And he said, this is crazy. So he started looking at the case and he asked the prosecutors, can we look at some can we do some testing again? Can we test this murder weapon for DNA? Can we test this hair that was found at the scene? So this attorney, just like Happily Angry Lawyer did, Jim R. did, said, I'm listening to this podcast about this guy's case. This seems crazy. Let's do something. So now he says here, this is his writing 2 days ago. I cannot imagine a greater satisfaction for a lawyer than overturning the wrongful murder conviction of an innocent person. After 6 years of hard work, we are about to cross the finish line. I will keep you posted. So then he has a statement here from himself, responding to a news outlet, where he told them, I very much appreciate your interest in Mr. Abramowski's case. However, I would prefer to refrain from making any additional statements until after this hearing on my motion to vacate his conviction and sentence. So, again, if there's some movement going on with Mungoun and you don't see Fit Lawyer Tiffany Adams, you don't see Happily Angry Lawyer Jim R., if you don't see them like diving into the nitty-gritty, it's because they're actively working on the case. They don't want to step on the wrong toes. They don't want to get motions to bar extrajudicial statements flinging at them, I'm sure. I think Jim would probably love to respond to that. But yeah, quick story here for, again, this is local to Brevard County. Jeff was in custody for 23 years. So we've got State Attorney Will Shiner, and, shout out to him for what he decides here. Again, he didn't oppose this motion to vacate the sentence. This is what he said. While the state maintains that the newly discovered evidence does not exonerate Mr. Abramowski, so maybe they'll decide to retry, that's not determined yet, the advancement of DNA testing and technology has resulted in the discovery of information that was not known to the state, defense, or the court at the time of Mr. Abramowski's original conviction. This discovery warrants the granting of a new trial for Mr. Abramowski. My office and team remain committed to the vigorous pursuit of justice for all. So there were some other statements where it was unclear if they're actually going to pursue a new trial. And for what it's worth, like, when there's new information, like DNA evidence, a change in the results of a DNA test that wasn't known at the time of trial, prosecutors shouldn't just sit there and go, oh, well, it's already done, who cares? So it's really nice, even though this guy might decide to retry, we don't know yet, it's nice that this defense attorney didn't have to sit here and pull teeth and go to court after court after court to ask for a hearing on new DNA evidence. And I know, Adventure Aaron, you're in the chat here. This was a huge issue with Marcellus Williams' case. He spent like 4 or 5, more than that, like 7 or 8 years asking for a court to finally hear DNA evidence that could exonerate him. And at the final hour, a judge is like, all right, let's do a hearing on it. Maybe we'll do it. Prosecution, at this point, it's a whole new prosecutor office. Wesley Bell was saying, let's overturn the conviction. I think there were flaws here. They're finally like, all right, there is new DNA evidence. Let's hear it. And then at the final hour, they're like, oh, the DNA found on the murder weapon that does not belong to Marcellus Williams actually belongs to 2 of our investigators that didn't properly handle the DNA. So it doesn't actually exonerate Marcellus Williams. So I believe the Attorney General went to the Supreme Court and told them that they don't have the right to allow the sentence, or they came to a joint agreement. And then the Attorney General stepped in, the prosecutors and the defense came to a joint agreement. And the Attorney General said, nope, you don't have, there isn't a mechanism for that to happen without a hearing being set. And then we had this whole issue come into play where it was really our investigators that messed up the evidence, so it's not good enough to take the death penalty off the table for Marcellus Williams. And then he, very, very saddeningly, was executed. But here, this prosecutor is at least like, this is important evidence, this is a new discovery, and while it might not exonerate him, it wasn't available at trial, and we don't have confidence in the result of that trial any longer. So I respect this. I respect that we have this story here coming out without a prosecutor fighting to keep the conviction and sentence in place. If you want to check out the podcast, let me grab the link. It was a season of Murders on the Space Coast. They did a whole season of their podcast devoted to this case. And we're going to call it Murder on Space Coast. Link is in the chat there if you want to check that out. But really, the original point of that was, you know, when we're around here, we're making a fuss, whether it's on YouTube, whether it's in a chat, whether it's on Facebook, over on X, wherever it is, on Twitch. This attorney, Mr. McCann, found out about this podcast, Murders on the Space Coast, and said, what the heck is going on? And then went and looked at the case, and now we're getting a vacated sentence because of it. So please don't ever think that it doesn't do anything to speak up on social media. I think it does. Again, I think Jim R., every time you see Happily Angry Lawyer, give him his flowers. Give Tiffany her flowers for, you know, when she was able to connect with Jim. She was like, heck yeah, let's do this. So both of them deserve their flowers for seeing something that didn't seem right and being able to do something about it. And again, a lot of that came from Jim being in here and seeing you guys point stuff out. And he started looking at the statutes, the charges according to Georgia statute for possession of a felon, previously convicted of a crime, of a felony. And he said, hold on, this something isn't right here. So he did all the redlining to put it together. But those attorneys like Jim, attorneys like Kevin McCann, attorneys like the Fit Lawyer, the stuff that they're doing is just, like, I wish more people were like that in whatever it is that they do. Somebody that cares, raises their voice, gets mad about stuff, and can actually propel a better outcome. And shout out to Adventure Erin in the chat as well. She does a lot of work in the post-conviction space. You guys probably just know her for being extremely insightful in the chat about legal issues and the facts of the cases that we're covering. But incredible person, a lot of drive and passion there for the wrongfully convicted. So big shout out to Adventure Erin as well. Peter Ortiz says, Kat, where is your new hat? I do have a new hat. I'm just not wearing it. I'll wear it on Cinco de Mayo. I will wear it on Cinco de Mayo. Let's see. We've got Chloe Albert's Revenge says Cinco de Mayo, now open pop-up shop, Vivaritos Burritos, get them while they're hot, only free $99 with a $40 tariff, get yours today. Now hold on, so this reminded me of ASAP Relly. I shouldn't even say ASAP Relly. If you guys missed it, ASAP Rocky, Rakeem Myers, in the personal injury case that Terrell Efron has against Rocky. This is not the case where it's personal injury and defamation and all of that against Rocky and Takapina. This is the first lawsuit, first civil suit that Terrell Efron opened. Rocky, Rakeem Myers, is moving to amend his first response because now that the criminal trial is over, the prosecution's over, there isn't that Fifth Amendment issue where if Rakeem Myers wants to raise in the civil suit a defense to what he's being, you know, someone's claiming he's liable for, if he asserted certain things in his response, it could have interfered with his right to not incriminate himself in the criminal proceeding. But now that he was fully acquitted in the criminal proceeding, he's added, I think, 6 additional defenses and is asking the court to allow him to submit this amended first response. So I linked that. Let me get the link. Let me get the link for you guys. And I think the next hearing on that is like May 21st or something for that particular action. Okay. And not to be a little snot, but Terrell's name is spelled wrong here. It's with 2 R's. Where did I put the link? Maybe I didn't. Oh, okay. Copy link. Alright, So Myers motion in the chat. You can also grab it over on X. But yeah, he just added additional affirmative defenses. So self-defense, defense of others, defense of property, necessity, consent, which is my favorite. It says plaintiff consented to and approved all the acts and omissions about which plaintiff now complains. Accordingly, plaintiff is barred from pursuing this action. So Relly consented to everything that went down that day. We have intervening or supervening cause and superseding cause. And then this 12th affirmative defense is pretty standard. It's just saying that I might have additional affirmative defenses I want to raise, but I'm not aware about it this time. Perhaps when we do some discovery, I might want to raise an additional defense. So I'm reserving my right to assert more defenses, shall they arise later. So there you go if you want an update there on the Terrell Ephron and Rakeem Myers saga there. Again, that is not the case that has Tacopina named as a party. Big shout out here. Full drinking and half thinking says, oh wait, hold on, wait, are you praying for the Cali homies? Daredevil, what's going on in California? Are these two separate thoughts? I'm always scared when I see someone saying pray for Cali. Because are there more fires? I'm out of the loop. So let me Google it. There was an earthquake? Oh my gosh. Earthquakes are so scary to me. Yeah, so prayers up there for the Cali homies. It's like I'm glad that there is no wildfire news, but then it's an earthquake instead, so that definitely sucks. And then, dang, I gotta like keep up with news a little bit better. Full Drinking Half Thinking also says Daredevil will give Spider the real deal issue. Superman and Spider-Man are soft. I don't know. So I love Daredevil. Like, honestly love that show. With Vincent D'Onofrio. Vincent D'Onofrio, the way he played that really reminded me kind of like Apocalypse Now. The way he got into his villain character. So I like that show a lot. I never saw the follow-up season. I think they did a second season, and I didn't watch that, so I'm only speaking on the first one. Chloe says, did someone say Relly Jelly? Not exactly, but now we did. Now we said Relly Jelly. Let's see. Yeah, Full Drinking and Half Thinking says, when you come to my show, you better wear them hoops. I always have them in, like when I leave the house, if I don't have a hat and hoops, I feel like I can feel the wind. I can feel the draft. So I don't really leave the house without him. Definitely got you on that one. And thank you for all your support. SteffJK! Shout out to SteffJK in the building. We missed you. We know you're working hard out there. Steph says, thanks, Kat, for a slime reunion. So nice to be home. It is great to see you. You've got an updated icon, but I can't read what it says. But it looks like an infinity symbol. So, if this is like a company or brand, help my old eyes, my aging eyes. I need to eat more carrots. But I see you have a new icon, so if it's a brand, let us know. Mrs. R says, miss y'all. We miss you right back. So good to see you. Super good to see you. Hold on, Jennifer Gardner. Was that her? Hold on, I'm so bad. She was the girl? I thought it was the blonde girl. Or you're thinking of the other Daredevil, I think. So. Right? Because there was like Daredevil the movie and then Daredevil the show. Yeah, I love Vincent D'Onofrio. Thought it was great. Hey to Candace, good to see you. And then, holy moly, hold on, I gotta go see what the sticker is. StreamYard is like goofy in that it doesn't let us see. Like, if you guys look at my screen, I think it just shows you super sticker. So holy crap, big thank you here to Peter Ortiz. It's an avocado on a Space Coast rocket ship. Ah, it's Space Coast themed, you guys. It's an avocado in space. Blasting off. That is me. That is me when I blast off of here to go get some food. This is super generous, Peter. Big thank you here for the super sticker. And And very nice that you're referencing here my Space Coast background here. You know, I am a New Yorker here that jokes that I retired early, moving down to Florida. That's why we're here. I never go to the beach. I should really do that. Maybe I'll stream and take you guys to the beach for like a casual stream. Maybe for like a rocket launch. That'd be cool. But yeah, I do love it down here. We've casually said we need to do a meetup. Because, I mean, meeting up, but it's an excuse to go to a beach. Cocoa Beach is fun. We could even do somewhere nearby. A lot of people like the Vero Beach area. So definitely got to make something happen. So huge shout out here. Let's get some booms in the chat for Peter Ortiz. The boom, 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 whatevers. Not to make a Relly Jelly reference. We're going to steal that reference and make it a Peter Ortiz reference with honor. So big thank you. I see Chelsea Lynn here saying I ate carrots for lunch at 30. We're doing all the things I didn't need. My eyes getting worse. Oh, goodness. Oh, and then Steph says this is for her record. Look at you go, Steph. Steph says it's for her record label. So let's get some booms for Peter, and let's get, like, I don't want to say socks. Slippy socks for Steph. Steph, we need, do you want the slippy socks? Because we can get some socks going for Steph. Because I know your music's fire enough that you gotta have the grippy socks so you don't slip while you're dancing to it. So we'll do some socks here for SteffJK. And we got some booms there for Peter going in the chat. So that is super awesome, you guys. With that being said, Peter, thank you for the walk-off sticker, the animation here. I'm going to go actually get some lunch. And I can't wait to eat. I usually eat by like noon, so I'm a little behind. It's really great to see everybody. See you sometime between now and the 21st, whenever the state responds to this mess. Or in the chat somewhere watching the Karen Reed trial. This stream is going to redirect to Lori Daybell with Survivor Speaks. So if you haven't gotten to see that, but want to catch a glimpse of the pro se mess with Lori Daybell Vallow representing herself, you'll get to see that over there with Survivor Speaks. Until then, you guys, see you next time. See you in a chat somewhere. And you guys all take care. Bye.